Notice how defense counsel jumps right in asking for more time. Classic move. Why? Because in criminal cases, discovery is everything. You don't fight a battle blindfolded. You need to see all the evidence first.
Mr. Smith, once you get to the podium, could you please state your name for the record?
Joshua Smith. Thank you.
Your Honor, today is the date and time set for a PCC in this matter. We would be asking for an adjournment of the PCC to complete discovery in this matter. I have gotten some initial discovery, but I believe there is more coming after speaking with Madam Prosecutor.
It's the only thing holding.
I'm sorry, Your Honor?
It's the only thing holding him.
Yes, it is, Your Honor. And we would like to address the matter of bond when the court is ready.
Trial's conference, July 11th.
July 11th?
Pause right there. Mr. Smith has been locked up for 9 days already. Imagine sitting in jail before trial, when technically you're still presumed innocent. Do you think that's fair, or just how the system works? Drop your thoughts below.
24, 9 a.m. Or as you're invited to the case.
Thank you, Your Honor. May I address the matter of bond, Judge?
You may.
Your Honor, Mr. Smith has no prior convictions other than possibly a driving while license suspension case. I did run his iChat and it was completely clean. He's been incarcerated for 9 days since June 18th. He has retained counsel and is serious about facing the matters in front of him. He's a 30-year-old man that lives in Ypsilanti and has an apartment he's prepared to go home to. He's a lifelong resident of the Metro Detroit area, growing up in Canton and graduating from Plymouth High School in 2013. He has extremely strong family support in this matter. His mom, dad, and sister all live in Canton, and his extended family out of the state has been calling to check in on Smith and help in any way they can. His mom is a Assistant Deputy Director of Field Operations in the Michigan Department of Correction, essentially in charge of...
Here's where it gets interesting. The defense argues that even if Smith were convicted, sentencing guidelines point to probation, not prison. That's a huge contrast to what the prosecution wants. This moment really shows how much math and technical guidelines drive courtroom outcomes.
Supervising parole and probation, or parolees and probationers. His dad is a retired worker from DTE Energy. His parents have borrowed from their retirement in order to retain counsel on his behalf. Speaking of Mr. Smith's work background, he's obviously resigned from his job due to this case, but he has been consistently employed since his senior year of high school, working in various industries like food service, manufacturing, trucking, and hospitality. He is confident that he can become employed should he be released in this matter, and he does believe he has a lead on a case or on a job to become a janitor. We have had a chance to review the police report in this matter, Judge. Now, I would note that there's no mention of any injury to the complaining witness or no mention of any medical treatment. Based on that police report, I've done a preliminary run of his sentencing guidelines, and assuming for the sake of the bond argument only, that if he were convicted of assault with intent to do great bodily harm and he were given points under OV3 for bodily injury requiring medical treatment, maximum points for psychological injury to the victim, and maximum points for exploitation of a vulnerable victim, the sentencing range would still be 0 to 17 months, meaning it would be an intermediate sanction since it's under 18-month sanction. And as this court is well aware, jail is not an intermediate sanctions. Presumptively, this would be a probation sentence.
I understand how sentencing works. Go ahead.
Whoa, did you catch that? The prosecution says Smith allegedly strangled a 14-year-old student with his sweatshirt sleeve. And it's all on video. This just escalated from routine bond arguments to something that sounds straight out of crime drama.
Okay, get to your end of your argument.
Okay, concluding, Your Honor, I would note that there was 14 days between the arrest and the incident in this matter where there was no allegations of wrongdoing. Mr. Smith was proactive in looking out and getting a booked therapy appointment, which we would like to get back to. We'd be asking for a cash bond that Mr. Smith can afford because we do not believe he is a danger to the community or a flight risk. We'd ask for a $2,500 10% cash bond in this matter, Judge.
Response.
Well, we originally requested $75,000 general surety in this case, and we were given $25,000 with 2% probation. This is the case that was captured on video. That was the teacher that is running the case for he was the victim and the defendant into a verbal argument. At one point, The defendant instructed the victim to shut up. When he told the defendant that he was unable to do so because he had a right injured, and at that point, the defendant got in the 14-year-old's face and said, "That's some bitch ass shit."
And then comes the defendant's own words. I snapped. I knew it wasn't right. That kind of statement is devastating in court. Question for you. If someone admits losing control, should that weigh heavier than the actual act itself?
The defendant then startling the victim as he started to walk away. And at that point, just was almost seconds with the sleeve structure. It was only when two teachers walked up and intervened that it concluded. The whole thing is on victim, is on video. The kind of physical acts that he did was extremely interesting because when his own words, his statement to law enforcement, when asked what happened, he said, "I got a headache and it was snapped." And he knew it wasn't first. So I was significantly concerned based on the nature of the physical facts, with all the harm in the video, also the defendant's own position here about what exactly happened.
May I have a brief rebuttal, Your Honor? Even with the
There was
serious,
a 14-year-old who was a teacher, and there was a strangulation.
those are the allegations, Your
Yeah,
Honor.
go ahead with your response.
Even with the seriousness of these allegations, fully recognize the seriousness. I think the guideline argument remains that this still is a presumptive probation.
And there it is. The judge slams the door shut. Bond reduction denied. The defense tried everything. Family ties, probation guidelines, even asking if mom's house would help. But the judge wasn't moved. What do you think? Was the judge too harsh or right on point?
And I think to the danger of the community, I think 14 days between between the incident and arrest, where there was no court order in place, where there's no allegations of wrongdoing, speaks to the danger in the community that Mr. Smith is, and I believe that danger can be mitigated with reasonable terms of bonds, such as possibly a tether or a cash bond that he may afford, which we would ask for $2,500, 10%.
There's a $75,000, 10% bond.
I understand, Judge.
They didn't request that I raise it. I actually should raise it, given what occurred. I will not. However, your motion for bond reduction is denied.
Your Honor, would you consider release if he was to live at his mother's house rather than by himself in Ypsilanti as a condition of bond?
Did I just? I thought I ordered something.
I was just asking if it would sway your decision at all, Your Honor.
No, when I'm done, I'm done.
Fair enough, Judge.
Thank you.
Thank you, Your Honor.